Hi everyone, welcome once again to Listen World. Today, let's go through the concept of right to equality. Yes, the most important article in Indian Constitution. We all know Part 3 of the Indian Constitution contains fundamental rights. Yes, from Article 12 to Article 35. Of these, Article 14 says about right to equality. A right to equality is one of the articles contained in the Golden Triangle of Indian Constitution. Then we can understand how important this article is. Article 14, Article 19, right to freedom, and Article 21, right to life and liberty are included in the Golden Triangle of Indian Constitution. Now let's move to right to equality in detail. Every human being is born equally. No kind of discrimination is there. So that the makers of the Indian Constitution have included the concept of right to equality or the equality for people in Indian Constitution. So Article 14, that is the concept of equality, is also included in the preamble. Another important point when we think about this article is that it imposes a duty on the state to abstain from discriminating people, but it also puts a positive consent to take such action by which the inequalities can be bridged between the people. Now, Article 14. When we think about Article 14, the two concepts that must come to our mind is equality before law and equal protection of law. The expression equality before law is a negative concept, as it imposes a duty on the state to abstain from doing any act which is discriminatory in nature. Under it, there is an absence of special privilege for a particular group of people. Everyone is considered equal, regardless of the rank of a person. He is subject to the same provisions of law. Thus, no person is above the law on the land, and all have to abide by it. Now, the term equal protection of law is based on the 14th Amendment of US Constitution. You know, we have borrowed the fundamental rights from the US Constitution. It tells the equal protection of law should be provided to all the people in India for the enjoyment of their rights without any privileges or favoritism towards any person. This is a positive concept because it implies a duty on the state to take actions for ensuring this right to all the citizens. Thus, both these expressions make the provision of equal treatment binding on the state. Look, there's a case that is what the Sri Srinivas Theatre versus Government of Tamil Nadu. In this case, the Supreme Court explained that both these expressions may appear to be same, but they have different meanings. The term equality before law is a dynamic concept. It's changed according to some aspects. One such aspect being that there should be an absence of any privilege or a person being above the law. Now, coming to the detail of these two concepts, equality before law and equal protection of law. Under equality before law, the principle followed is like should be treated alike. It means that the right to sue and be sued for the same cause of action should be same for the people who are equals. That is, a person or the people who are in similar circumstances, and such rights should be available to them without any discrimination on the basis of religion, sex, caste, or any other such factor. There exists many discriminations still. Now, another case, that is State of West Bengal versus Anwar Ali Sarkar. The court held that the term equal protection of law is a natural consequence of the term equality before law. And thus, it's very difficult to imagine a situation in which there has been a violation of equal protection of laws, not a violation of equality before law. Actually, if there is a violation of equality before law, it is a violation of equal protection of law. So, while they have different meanings, both the terms are interrelated. Now, the rule of law. The concept of rule of law is given by Dicey. Rule of law means the basic principle, that is, no person is above the law. Equality of law is a part of rule of law. Daisy had given three meanings to this rule. One is supremacy of law. Law is supreme. People should be, law is supreme and the government should not act arbitrarily. If a person has violated a law, he should be punished, and not the government should not take it at the whim of them. Now, equality before law, it means that all the persons should be subject to the same provisions of law, which is administered by the ordinary courts of the land. Thus, no person is above the law and has to follow the law. Dicey had given an exception to the monarch under this rule, because in England it is believed that king can do no wrong. Even though king has done some act which is wrongful, it is considered that it's not a wrong. Actually, that concept is over. Still, he just made it an exception. Now, the third rule is that constitution originates from the ordinary law. The ordinary courts have some laws, and the constitution is made according to that. These three rules, or these three meanings, are given to the rule of law. But in India, the first and second rule is only adopted, and the third rule is completely omitted. As we all know, constitution is the supreme law, and all other laws are under it. When a law is violated, or when any kind of ordinary law violates the provisions of the constitution, is actually not cannot be done. So that is it, and there is an exception for the equality before law. That is not an exception. It's under Article 105 and 194. The members of the Parliament and the state legislatures respectively are not held liable for anything within the houses of Parliament, that is Rajya Sabha or Lok Sabha. Under Article 359, when there is a proclamation of emergency, all the operation of fundamental rights, including Article 14. What is Article 14? Yes, right to equality can be suspended. And if any violation of this right is done during such proclamation, cannot be challenged in the courts after the proclamation ends. Now, under Article 391, the President and the Governor are not liable to any court for any act which is done by them in exercising their power and duties of the office. I think that now the concept of equality before law is somewhat clear. Now we can move to the concept of equal protection of laws. Equal protection of law imposes a duty on the state to take all the necessary steps to ensure that the guarantee of equal treatment of people is followed. Like people being treated alike is followed under this rule. And another important point under this rule is that unlike should not be treated alike. Thus, even if people who are under different position and circumstances are governed by the same rule, then it will also have a negative effect on the rule of equality. The rule of equality is not provided. So, some kind of privileges are to be given for the unlike people. Unlike people should not be treated alike is also included. Now, Article 14 and reasonable classification. Article 14 has provided the provision for equality of people before the law, but every person is not the same. And therefore, it's not practically possible to have a universal application of equality. Thus, the laws cannot be of a general character and some classification is permitted under Article 14. Thus, the legislator has been allowed to identify and classify different people in groups because it has been accepted that treating the unequal in the same manner is likely to cause more problems instead of preventing them. So, for the society to progress, classification is important. This classification cannot be done arbitrarily because in such case there will be no justification. So even though Article 14 allows for classification, such classification should not confer special privileges to any group arbitrarily, and such a classification has to be done on a rational basis. For example, the legislature cannot pass a law which favors a particular caste of people without any rational basis for it, and if such a law is passed, it is bound to be held unconstitutional by the judiciary. Such arbitrary classification by the legislature is known as class legislation, and it is forbidden by the Constitution, but it allows for reasonable classification in which the legislation is passed on a reasonable basis for the purpose of achieving some special objectives. Now, the test of reasonable classification, how the reasonable classification can be done. For determining whether a classification made by the legislature is reasonable or not, a test is used, and when a classification fulfills the condition of the test, it is held to be a reasonable one. It's normal, quite normal. The following are the tests for identifying the reasonable classification. The classification should not be arbitrary, evasive, and artificial in nature. This is the first test for checking the reasonability of a classification. This test is used to check whether the classification is based on some substantial distinction or not. The classification should be based on an intelligible differentia which can be understood, intelligible differentia, and should not be some made up the distinction. For example, classification of people based on their income is a reasonable classification for the purpose of Article 14. The person who have higher income and lower income. So the lower income people are to be classified in order to what? To reach up to the, not up to the higher income, but to a normal average income. The differential which has been applied in the classification should have some real and important connection with the objective which is sought to be achieved by the classification. For example, if the legislature has classified the people on the basis of their income, one of the objectives can be to provide some benefits of the people with lower income, such as exemption from tax. Here the differentia for classification is connected with the objectives of providing some benefits to the people earning low income, and therefore this classification is what? Valid. It's a reasonable classification, so it's valid. But the Supreme Court in Rees Special Courts Bill had warned against overemphasizing the classification. The court observed that the doctrine of classification is a subsidiary rule which has been used by the court to facilitate the doctrine of equality. If there is an overemphasis on the doctrine of classification, would inevitably result in the doctrine of equality under Article 14 to erode and will lead to the substitution of equality by classification. Now, a new concept have been derived to equality. After several cases, the concept of equality under Article 14 has gone through many changes, and now the present concept of equality has a greater scope as compared to its scope at the time of Constitution's enactment. In the case of, it's an important case, Air India versus Nagesh Mirza, the regulation of Indian Airlines provided that an air hostess had to retire from their services on attaining the age of 35, or if they married within 4 years of their service, or on their first pregnancy, whichever occurred earlier. The court held that terminating services of an air hostess on the grounds of pregnancy amounted to discrimination, as it was an unreasonable ground for termination. Is it? You can also understand that it's an unreasonable term or ground. The regulations provided that after 4 years of service, the air hostess could marry. Therefore, the grounds of pregnancy was not reasonable. Thus, it was held that this regulation flagrantly violated Article 14, and such termination would not be valid. Similarly, in the case of D.S. Nakara versus Union of India, Rule 34 of the Central Services Rules was held to be violating Article 14 and thus unconstitutional. Under this rule, a classification was made between the pensioners who retired between who retired before a specific date and those who retired after the date. Such classification was held irrational by the court and it was arbitrary. Thus, it was an infringement of Article 14 and as a result was set aside. In the case of another case, Bachan Singh versus State of Punjab, explaining the new dimensions of Article 14. Justice P. N. Bhagwati had observed that rule of law permeated the entire fabric of the Indian Constitution and it excludes arbitrariness. According to him, whenever there is arbitrariness, there is a denial of rule of law. So, every action of the state should be free from arbitrariness, otherwise, the court will strike the act as unconstitutional. The scope of the new concept of Article 14 is far greater than just being equated with the principle of reasonable classification. It guarantees against any arbitrariness which may exist in the actions of the state, and the doctrine of classification is merely a subsidiary to this article. Now we can conclude. Article 14 of the Constitution is part of the fundamental rights under Part 3 of the Indian Constitution, and it is regarded as one of the most important articles of the Constitution. Article 14 provides for equality of all people and absence of any discrimination on the grounds such as sex, caste, religion, etc. Under Article 14, two important aspects have been included, which are equality before law and the equal protection of law, and both of them play an important role. Under Article 14, the concept of rule of law has been adopted, under which no person can be said to be above law and every person has to abide to the provisions of law. But the equality which has been provided for under Article 14 is not universal, and the principle of equality among the equals is followed. This is the reason why many laws are made with some people, such as laws for the benefit of children. Such classification is reasonable and not arbitrary. The new dimensions of Article 14 have been developed by the judiciary, and the main purpose of Article 14 is to remove any arbitrariness which may exist in the actions of the state, and thus this article has a much wider scope in the present time as compared to its scope at the time of enactment of the Constitution. Thus, the scope of this article has been enlarged by various judicial pronouncements. Now, I have discussed about the concept of right to equality and the two important concepts coming under it, equality before law and equal protection of law. I think these were clear, and if you need to know more about it, just comment below, and also if there is any false in what I said, that also please comment. That's all. Do subscribe to my channel. Thank you.